I have to inform the members that the Honorable Chairman has received a letter dated the 10th of August 2017 from Sri M. Venkaiah Naidu, member representing the state of Rajasthan, resigning his seat in the Rajya Sabha. The Honorable Chairman has accepted resignation with effect from 10th of August 2017. Now, Honorable Minister, reply.
So I am extremely grateful to the members who've all expressed a very serious concern as far as the rising NPAs is concerned. In fact, Mr. Jairam Ramesh made a very elaborate opening speech, and I do agree with him on a large number of points that he stated. There is nothing wrong, as he rightly said, with loans being given. There is nothing wrong in banks then trying to effect, as per their due process, the recovery of those loans, because it's only on the strength of banking finance that business expands and jobs are created, the economy moves on. But the loans have to be serviced. And therefore, as long as a loan is a service, the asset itself available with the bank is a performing asset. The moment the debtor loses his ability to service the loan,
but only for laying.
After due notice, after the period of 90 days, it becomes a non-performing asset because the bank is neither then getting the principal nor getting the interest. There is yet another category called the willful defaulter. The willful defaulter is a person who's acted fraudulently, who's diverted the money, made false representations, siphoned the money, etc. Now let us be very clear, because these points occasionally come up. As far as these willful defaulters are concerned, there is no prohibition on either publishing their names or photographs. In fact, all the willful defaulters, names and photographs are even published by advertisements. These are the fraudulent ones. But as far as normal commercial transactions are concerned, for instance, any one of you, why should your normal loan account, even though some money may be due to the bank and you are not a willful defaulter, should be published in the newspaper as to how much loan you have taken, how much money is available in your bank, or your income tax return? Similar provision also is with regard to tax laws. Then there are provisions in either the Banking Regulation Act or in the Income Tax Act which gives a certain amount of responsibility that normal commercial details are never published. But in the case of willful defaulters, there is no prohibition, it is regularly published. So let us be very clear on this. Secondly, diverting from the issues, nobody has ever taken more action than this government has on all the foreign account details which have come. Every account in Panama has been investigated. We have a rule of law. We don't have a system like our neighboring country that you remove first and then have the trial. We first make our own investigation. So on each one of those cases, whether it is the Liechtenstein cases or the HSBC cases or the other cases which have come to notice or the Panama, in each case of the case, we have been in touch with the regular authorities of the countries where those accounts are. Prosecutions are being filed wherever the documents are coming. Assessment proceedings are being cleared. And there is no prohibition on publishing their names once the prosecutions are filed, because they are filed in India in an open court. Except when, as long as you are investigating the matter, one of the considerations which is taken into account in order to get cooperation from the foreign country is, till that time you don't use it for a political purpose or any other purpose. The secret confidentiality clause only applies till then, but once you file it in a court proceeding, then the confidentiality itself ceases to exist. Now, it is true that the NPA figure is rising. You linked it to my tenure, Mr. Rajya. It has nothing to do with my tenure, except that after I took over, the interest keeps rising. The interest didn't stop on that day. These are all old loans. So you must know the basic commercial principle that the interest keeps rising. Now, the very pertinent question Mr. Jairam Ramesh raised was, what is the exact amount? In the PSB banks, the amount as of 31st March 2017 is about 6.41 lakh crores. And then there are stressed assets, which if included in this come to about 8.02 lakh crores. Now, this figure will keep on fluctuating because some money comes back or some interest keeps getting added. The scheduled commercial banks, the figure would be different because that also includes the private sector bank. Now, partly Mr. Jadhav gave an answer to your query. Why do you bring a regulator in it? RBI is not merely a regulator in India. If it were, you probably had a valid point. Mr. Jadhav gave an answer that RBI has been performing other functions also in relation to social sector. And for instance, the public debt management is not a regulator's function. Some people believe there is a conflict between a regulator and a public debt management, but we've given it consciously to the RBI. The other reason is the government as a shareholder of these banks can at best tell the banks, but it's for you to consider whether management of the public sector banks from North Block is the right policy. Because a lot of ills in the past have flown from there. And therefore, the government need not start micromanaging the operations of the banks itself. But these are loans which are given by a consortium. For instance, a loan may be given by 20 banks. Now, you may have 5 private sector banks and 15 public sector banks. Obviously, the government has no power then to issue those similar directions to the private sector bank because we are not a shareholder as far as private sector banks is concerned. But RBI has under its act and under the empowerment which we are giving a jurisdiction over all of them. And therefore, the RBI is not selecting farmers. RBI is not, in fact, they are specifically excluded. RBI is not selecting some students or any small loan of 5 lakhs or 20 lakhs or 1 crore rupees. That energy is not to be wasted. As you all have been suggesting, Mr. Tapan says knows very well, he is connected with the trade union movement, that it is the big defaulters who have been selected, and in this case there are 5,000 crores and above. So somebody has 45,000 crores and 40,000 crores owed to the banking system, and therefore you need to get cracking as far as those loans are concerned. In some of these cases, the situation that if the banks go to the DRT, it will take its own time, the appeal and so on. In securitization, your bank takes over the asset. Then these people say, what do you do with that asset? Does the bank have the capacity? We also explored whether we can make a sample of one steel company, one power company, one port company, and hand it over to the concerned PSUs in these sectors to manage. The PSU said, we have enough problems of our own. Why do you saddle defaulting companies on our head? So we've explored all this. And the insolvency mechanism, Sukhendu has a very tight time schedule. People will try and go to court. Competent lawyers like you will argue for them. But then courts also have some sense of equity. Somebody owes 30,000 and 40,000 crores to the government, to the banking system, and the court will say, don't proceed against him. You are right, one person tried. One of these defaulters tried, and the argument was, why select me? There are 100 others who have not paid back the banks. Yes, sir. And the governments and the banks and the RBI's response was, this is for the first time that you are claiming an equality in the matter of not paying the banks back. Treat all defaulters alike. Now, this is an unsustainable argument, and I'm glad the court threw out the challenge. The court threw out the challenge, so there is no stay. So the list of 12 people that you read out are exactly the 12 against whom the RBI recommended in the first round. In the second tranche, the RBI is making its own analysis. Now, in the case of governments, you may say, well, the government has a motivation in selecting A and excluding B. So the government maintains its arm's length distance. The RBI is just directing the banks, and this includes the private sector banks also, which the government can't do, and say collectively move the insolvency. Now, the moment they move the insolvency, in some cases, insolvency professional is appointed as an administrator. Somebody is asked to look after the company. And now will be the next stage where people, including funds, foreign funds, asset reconstruction companies, domestic companies will come up and say, well, I am willing to take over this asset. Some company may take it over for the purpose of running the management. In some cases, we are reading proposals coming every day. In some cases, they will come and take over the asset. And of course, there will be commercial bargains in the process between the banks, supervised by the National Company Law Tribunal, as to on what terms they take it over. And finally, you will see some activity starting that the banks are paid, the asset is run, the investment is put in, and some activity starts as far as this company is concerned. This is our hope. These are parallel systems. The DRT is one system, the securitization is another system, the schemes under the RBI are other systems. And I think this is one move which has shaken the defaulters and which has a potential, because so far India has moved on the principle that till such time you take the loan, you run after the bank, and thereafter the bankers run after you. And then the creditors keep chasing the debtor, and the debtor virtually has nothing to offer. The assets may become rusted. This has now reversed the trend, where once you start the insolvency proceeding and in 180 days' time, there is a danger that on the second month or the third month, the NCLT will say, you go out, somebody else will run the company, and then we will see who comes and takes over this company, or there is a joint venture, or you sell your shares, etc. So there is bound to be a displacement as far as some of the managements are concerned. Some may settle. And I can tell you, for the first time, the defaulters have started now running after the banks. We want to settle on these terms. We want to get a partner. They are at least trying to come out with some solutions, and the activity has started. And therefore, my plea to the honourable members is the other house also in one voice supported this legislation. And therefore, this being a legislation which deals with the problem of the country, I can't say that any political party has created this problem. This is a problem which has emerged out of our economic system, and we must find a solution to this. With these words, sir, I commend this bill to this.
Thank you very much. Yes, no, there is no time. There is no time.